Now with me, CNN legal analyst and criminal defense attorney Joey Jackson. So, Joey, choosing to represent himself has already come with, I'm going to read this, Ryan Routh challenging Trump to a quote-unquote beatdown session or a round of golf, adding that if he wins, he can execute me. I win, I get his job. That coming out in court filings, not necessarily out in jury selection. Now you have these questions he wants to ask the jury. What do you make of it? What does it do?
It makes it into a circus. Make no mistake about it, Kate, good morning to you. These are significant charges. He could spend the rest of his life in jail. Judge warned him, saying, hey, listen, you have able counsel. You should avail yourself of those able counsel. There are procedural rules that you have to follow in admitting evidence and precluding evidence, etc. He opted, as the Constitution allows, to waive his right to counsel to go forward. I think, though, Kate, that the judge will keep him on a short leash, give him some leeway, and that if he becomes disruptive or things go off the rails, she'll say, you know what, because there's counsel standing by. Stand by counsel, step in and finish this up. I mean, he's making a mockery of it. There's nothing too funny about it, given the consequences involved.
Why does he want to? It's so high risk. Why would he want to represent? Why does anyone ever want to represent themselves? So
what you find, and of course people's motivations are their own, right? So you can only read into it. But what you find is that sometimes A, people just want to be heard. B, it provides a significant platform, and you could tell by the questions he's asking about Gaza, etc., that he wants that platform. And I think he wants to use this to indicate his real disdain for the president of the United States, in addition to the policies. I think he'll use it for that. But he needs to be careful. Trials are about what they're about. They're not about what's happening in the world. They're about what's happening in the courtroom. They're about the evidence pertaining to your guilt or lack thereof. And if you don't focus on that, they become irrelevant, which becomes objectionable, which means objection sustained. It's not admitted for the jury.
The charges that he's facing, I think we had them up, they include attempted assassination of a major presidential candidate, assaulting a federal officer, being a felon in possession of firearm and ammunition, possession of a firearm with an obliterated serial number. How high is the bar here for the prosecution to prove this case?
So I think there's a lot of evidence, right? So whenever you talk about criminal law, you look at a person's mind, the mental state, right? What is your intention? And I think that's what prosecutors will do. They'll look at issues like premeditation. What was he doing? And they have these records with respect to him tracking the movements of then candidate Trump. Where's he going to be such that I can be there? In addition to that, they have him staked out at that location. They have the items he left, including a rifle at that location. They have photos apparently of him going away. They have photos of the SUV he was in. They caught the SUV. They have indications that he made an admission and confession that it was him. So I think they will look to the evidence and the proof with respect to what his intentions were. Did he possess a firearm? Was he a felon when he possessed it? Did it have a defaced serial number? And what was he attempting to do? The message he was attempting to send? And what, if any, criminality he engaged in? And remember, Kate, he wasn't successful, but you can still charge attempt because you need a substantial step in the direction of the crime. I think they have that here. Difficult enough if he had an attorney. Without one, wow, it's such a task.
Joey, it's good to see you.
Always.
Thanks, you so
Kate.
much.